According to the Universal Declaration of Human Rights, freedom of speech is a human right. Freedom of speech was first introduced in the Magna Carta in the year 1215, and Socrates argued in favor of free speech even as far back as the year 399 BC. Freedom of speech was extremely important to our country's founding fathers. Benjamin Franklin's brother was imprisoned by the state of Massachusetts for criticizing the government's officials 5 years before the signing of the Declaration of Independence. 16-year-old Ben Franklin started writing essays in newspapers under an alias, arguing for the importance of free speech. James Madison agreed, drafting the Bill of Rights, putting the freedom of speech in the First Amendment to our U.S. Constitution. The First Amendment says, Congress shall make no laws respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievances. But what does that mean? This right allows individuals to express themselves without government interference or regulations. Now, freedom of speech can be expressed in either words or action, but it only applies to the government limiting speech. But what happens when the government feels that they have a really good reason to limit a specific type of speech? Well, that depends on whether or not the government wants to regulate the content of the speech or just the time, place, or manner that the speech occurs. When the government wants to regulate the content of the speech, the U.S. Supreme Court requires that the government show a substantial justification for the limit. This means that if the government passes a law forbidding you from saying, "The president is bad," because they don't like the message, the government must have a substantial reason for doing so. Limiting this kind of speech is presumed unconstitutional because the law's reason cannot pass this strict scrutiny test. For example, it was declared unconstitutional by the U.S. Supreme Court for the government to require you to salute the flag, or for public schools to require a student to take off an armband protesting a war, and for the government to pass a law forbidding people from burning the U.S. flag. But what if the government simply wants to limit the time, the place, or the manner of the speech, but not what you say specifically? Well, in that case, the government must show a significant reason for the law. The law must be narrow, and you must be able to get your message out in other ways. This test is called intermediate scrutiny, and it is easier for the government to uphold the law. For example, according to the United States Supreme Court, the government was allowed to pass a law prohibiting people from yelling fire in a crowded theater. This was done to protect people's safety, or to prevent the distribution of obscene materials. And also, a school can prohibit a student from advocating for illegal drug use at a school-sponsored event. In all those cases, the U.S. Supreme Court held that there were other places and times that the speakers could get their message across, and that the government had an interest in limiting the time, place, and manner of the speech, but not the message. So here are the law school thought questions. When does limiting the time, place, and manner of the speech really mean you're just limiting the content of the speech? For example, if you protest on the sidewalk in the middle of rush hour traffic, and the government tells you you can only protest between the hours of 2 a.m. to 4 a.m., is the government really limiting the content of the speech by disguising it as a time restriction? Or what about when is the government's interest substantial to actually limit the content of the speech? What if Congress passes a law forbidding anyone from distributing materials, advocating for overthrowing the government? What do you think? Leave your opinions in the comments below. Thank you for attending this law school at home. Class dismissed.